ये मैटर जो मैं आपको बोलने जा रहा हूँ, आप इस मैटर को हमारे सॉफ्टवेयर पे टाइप करके आप अपनी मिस्टेक्स को जान सकते हैं और अपने शॉर्टहैंड को इम्प्रूव कर सकते हैं, जिसका लिंक मैंने अपने डिस्क्रिप्शन बॉक्स में दे दिया है।
3, 2, 1, start. This appeal takes an exception to the judgment of the High Court in the second appeal preferred by the appellants. Stop. Appellant number 1 was the first plaintiff and appellant number 1 as well as appellant number 2 were the co-plaintiffs. Stop. The original first respondent was the defendant in the suit. Stop. For convenience, we are referring to the parties with reference to their status before the trial court. Stop. The defendant Brijbhushan Chaudhary executed an agreement for sale dated 16th January 1980. For short, the suit agreement in favor of plaintiff number 1, Major General retired Darshan Singh, in respect of plot of land at measuring approximately 20,000 square yard with structure thereon being residential house number 33 number 2829 sector 2A Chandigarh. Stop. The agreed consideration was rupees 35 lakh. Stop. A sum of rupees 30,000 was paid by the plaintiff number 1 to the defendant by way of earnest money. Stop. The sale deed was to be executed on or before 30th April 1980. Stop. Clause number 3 in the suit agreement provided that in the event of failure of the defendant to honor the agreement, his liability will be to refund the sum of rupees 30,000 along with damages of rupees 10,000 without any interest. Stop. The clause further provided that plaintiff number 1 will have no right to claim any other damages or to file a suit for specific performance. Stop. According to the case of plaintiff number 1, there were further negotiations after the execution of the suit agreement and it was agreed to reduce the price to rupees 2,90,000. Stop. Consequently, a draft sale deed was executed between plaintiff number 1 and the defendant on 18th March 1980. Stop. We may note here that along with plaintiff number 1, his daughters Raman, Pawan and Narveen were co-plaintiffs. Stop. All of them were signatories to the draft sale deed. Stop. According to the plaintiff's case, necessary sale permission under the Urban Land Sealing and Regulation Act 1976 was granted on 11th August 1980. Stop. The plaintiffs claimed that on the date of execution of the draft sale deed, they were put in possession of the suit property. Stop. The plaintiffs purchased stamp paper worth rupees 23,000 on 19th July 1980 as desired by the defendant. Stop. According to the plaintiff's case, the defendant changed his mind and there was a price rise of the properties in the vicinity of the suit property. Stop. Therefore, a telegraphic notice was issued by the plaintiffs to the defendant on 26th August 1980, calling upon him to remain present in the office of the sub-registrar at Chandigarh on 29th August 1980 between 10 am and 4 pm for registration of the sale deed. Stop. The case of the plaintiffs is that notwithstanding the service of the said notice, the defendant neither replied nor remained present before the sub-registrar for registration of the sale deed. Stop. Therefore, a suit for specific performance was filed by the plaintiffs. Stop. In the alternative, the plaintiffs claimed relief of damages of rupees 40,000. Stop. The defendant contested the suit by filing a written statement in which he contended that the suit property belonged to his Hindu undivided family and the members of the family were in joint possession of the suit property. Stop. The defendant denied that the possession of the property was handed over to the plaintiffs. Stop. replication further pleading was filed by the plaintiffs dealing with the averments made in the written statement. Stop. The trial court declined to grant relief of specific performance and passed a decree of damages in the sum of rupees 40,000 payable to plaintiff number 1. Stop. The suit as regards plaintiff numbers 2 to 4 was dismissed. Stop. The trial court framed 11 issues. Stop. The trial court held that though there was a clause to the contrary in the suit agreement, it would not bar the plaintiff's remedy to seek a specific performance. Stop. The trial court held that the suit property was the property of the defendant's family. Stop. The trial court held that the theory of the plaintiffs that there was a fresh agreement under which the price was reduced to rupees 2,90,000 was not established. Stop. The trial court also held that the possession of the suit property was not handed over to plaintiff number 1. Stop. The trial court further held that plaintiffs numbers 2 to 4 were not parties to the suit agreement and hence they are not entitled to maintain a suit for specific performance. Stop. On the issue of readiness and willingness, the trial court held that as the plaintiffs had kept the demand draft in the sum of rupees 26,000 ready, it cannot be held that they were not ready and willing to perform their part of the agreement. Stop. The appeal filed by the appellants before the district court was dismissed. Stop. The district court held that though, even according to the case of plaintiff number 1, the suit property was HUF property, there was no pleading that there was a legal necessity for the sale of the HUF property. Stop. Moreover, the co-sharers of the defendant were not made parties and the plaintiffs had not given up their claim against the co-sharers of the defendant. Stop. While dismissing the appeal, the district court held that the trial court's finding on the issue of readiness and willingness was correct. The High Court in the second appeal held that the suit property was the HUF property. Stop. Relying upon the decision of this court in the case of Balmukund versus Kamlavati, the High Court held that the suit property was imperitable under the provisions of the Capital of Punjab Development and Regulation Act 1952. Stop. Therefore, the High Court confirmed the decrees passed by the trial court and the first appellate court. Stop. The learned counsel appearing for the appellants pointed out the concurrent findings on the issue of readiness and willingness in favor of the plaintiffs. Stop. Therefore, the plaintiffs satisfied the test laid down by Section 16C of the Specific Relief Act 1963, for short 1963 Act. Stop. He relied upon several decisions of this court in support of the proposition that a decree for specific performance can be passed concerning an undivided share of the defendant in the suit property. Stop. He relied upon the decision of this court. Stop. The learned counsel relied upon another decision of this court in the case of Surinder Singh versus Kapoor Singh and submitted that in view of clause A of section 22 (1) of the 1963 Act, a decree for partition and separate possession can be granted in addition to a decree for specific performance. Stop. Therefore, the trial court ought to have molded the relief by granting a decree of specific performance concerning the undivided share of the defendant. Stop. He submitted that a part of the contract can always be ordered to be performed based on the principles laid down in section 12 of the 1963 Act. Stop. He submitted that the suit property can always be subjected to a partition. Stop. If it cannot be subjected to a partition, the shares of the co-sharers can be auctioned. Stop. Therefore, the trial court ought to have passed a decree for specific performance limited to the undivided share of the defendant. Stop. The learned senior counsel appearing for the defendant invited our attention to the conduct of the first plaintiff and submitted that the conduct as seen from the record requires the court to exercise discretion under section 20 of the 1963 Act. Stop.